الحمد لله رب العالمين حمدا يوافي نعمه ويدافع نقمه ويكافئ مزيده ولك الحمد حتى ترضى ولك الحمد بعد الرضا لك الحمد كما ينبغي لجلال وجهك ولعظيم سلطانك سبحانك لا نحصي ثناء عليك أنت كما أثنيت على نفسك اللهم أخرجنا من ظلمات الوهم وأكرمنا بنور الفهم وافتح علينا بمعرفة العلم وسهل أخلاقنا بالحلم واجعلنا مما يستمعون القول فيتبعون أحسنه اللهم اجعل أعمالنا خالصة لوجهك ولا تجعل فيها حظا لغيرك يا مقلب القلوب ثبت قلوبنا على دينك آمين اللهم لا تحرمنا خير ما عندك وشر ما عندنا وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين فالسلام عليكم ورحمة الله وبركاته. How's everyone? Alhamdulillah Rabbil Alameen. I think this is likely the last class. Uh, People are different ways. They don't think that they will see the moon. I think they will see the moon. I hope they don't, but I think they'll see the moon somewhere. طيب. So we're still studying Islamic contract law, and thus far we have reached the point where we're speaking about khiyar. And khiyar, as we had mentioned before, is that the Sharia has given the contracting parties options. And these options are generally options to terminate the sale, right? Or to annul the sale, or to ratify the sale, right? And this option is either connected to the contractual setting, or it is stipulated in the contract, or it comes about on account of a defect, right? So we spoke about the contractual setting and how khiyarul majlis, which is the name for the option of terminating during the contractual setting, how it takes place and how long it lasts, right? As well as how that would occur when the two contracting parties are not in the same place. Thereafter, we spoke about khiyarul shart, and we spoke about the fact that a person can stipulate to decide whether or not to ratify the contract for a period of up to 3 days. And we also mentioned the view of the Hanabila, right? As well as the Sahibain, the two of the three leading scholars of the Hanafi school in relation to the extension of this period beyond 3 days, right? And we mentioned that in light of the Consumer Protection Act, which gives a person the minimum of 7 days to terminate, right? So though that falls outside of the Shafi'i madhab, it falls within the Hanbali madhab as well as the Hanafi school, right? Why is that important? It's important because of mutalaba, that when we say that the person can only stipulate 3 days, it means that this, in the Shafi'i school, it would mean that any stipulation beyond 3 days is not binding. Is not binding. So it's important to understand that. So now we come to something called shartul bara'a min al-aib. And shart al-bara'a min al-aib is a type of invalid sale. Right? So though we have not reached invalid sales, we introduce this over here because it's got to do with shart. It's got to do with stipulating a certain type of condition within the contract, right? And what is this? This is that stipulating that one is absolved of defects, right? So amongst ourselves, when we sell goods, especially when we sell second-hand goods, right, then we find that this phenomenon is widespread. That the person says, I sell you this thing as is. I sell you this thing as is, right? And the person by that means would seek to absolve themselves of all defects that exist in the item, right? They might even tell you, look, non-refundable, no returns. So what is the ruling regarding this point? Can a person absolve themselves from the responsibility of defects in a good in such a way in goods in such a way, or can they not? Right? And this commonly referred to as food stewards. Isn't it? So you sell something, food stewards. As is, normally it's second-hand things, and the person won't give you the option to sell it back. So Mawlana says, to stipulate that one is absolved of defects is not allowed except in very specific conditions. Right? So generally, a person will not be allowed to absolve themselves from defects. They will not be allowed to absolve themselves from defects. There are some exceptions to this. What are those exceptions? Right, and we're reading on page number 63. The first example is the example of an animal. So we find that animals are like the volatile creatures. The animal can become sick anytime and become healthy the next day, right? So it's not possible for the owner to be acutely aware of the internal health state of the animal at all given times, right? Or at all times. Therefore, if a person sells an animal, right, and absolves himself from the defects, meaning that the animal is sound, right, in the current condition, and they absolve themselves from any sickness that might be latent within the animal, that will be accepted. Right? Because the owner is not responsible to check continuously on the health condition of the animal. This is especially in the case of sheep and the like, right? The health is very volatile. So it wouldn't be a fault of the owner to say that I absolve myself from such defects. Right? Beyond this, the seller is obligated to inform the buyer of all defects that exist. If he doesn't, and he knows that there's a defect, right, the buyer will have the right to return the goods, and he would have deceived the buyer, and that action would have been haram. Right? That's why the Prophet ﷺ said, "Man ghasha minna, man ghashana falaysa minna." Whoever deceives us, they're not from amongst us. Whoever deceives us, they're not from amongst us. Right? So, shart bara'a min al-aib, to stipulate that one is absolved of defects at the time of sale, will not be permissible. Right? Now, okay, we explained that. Then the next thing that Mala wants to speak about is ghash. Ghash here refers to deception. Right? So deception refers to the person presenting the contracted item in a manner that does not represent its reality. Right? A manner that does not represent its reality. One of the most common examples of this, right, in previous times was something called tasriya. And tasriya meant that when you had an animal that was a milk-giving animal, right, and that was used for its milk, then you wouldn't milk it for a few days. Right, such that the others become full, so that when a person comes to look at the animal, they think, MashaAllah, this is an animal that, it's got a lot of milk. But in actual fact, the animal just hasn't been milked for a few days. You understand that? So here the person is presenting the contracted item in a manner that gives the buyer the impression that it is of a certain quality when it's of a different quality. Right? So this will be haram, and the person will have the right to return the goods. Right? Similarly, in times gone by, slavery and the buying and selling of slaves would be widespread. So what the person would do is that a person would dye they would redden the face of the slave girl, right, to make her look younger, and they might dye the hair of a male slave black, right, to give him a younger appearance when he's actually older than what he is. These were all forms of deception regarding the contracted item, and they would give the buyer the right to return them when he finds out what that this is in fact deception. Mona says that in our age, people have become experts in deception when it comes to the contracted item, inventing new ways to deceive others. And it is to Allah that we turn for help. Right? And we says if we had to mention exhaustively all the examples of how people deceive, then this book would have become very long. This book would have become very, very long. Right? Some examples include selling fake goods under the pretense that they are real. Right? So that's like one of the most common ones. However, we do say that Malana is not saying here that the production of fake goods is haram. He's saying that selling fake goods under the pretense that they are the original goods is haram. These are two separate matters. So the matter of patenting and copyrighting, whether or not you can actually make another shoe that looks like a Birkenstock, is one thing. Right? And the second thing is that you sell a shoe under the pretense that it's a Birkenstock. So here, under the pretense that it's a Birkenstock, this is what is haram. As for the case where a person designs another shoe, it's not a Birkenstock, but it looks like a Birkenstock, here we're going to have a different discussion, right, that we're not going to get into now. Another example of this is ambiguously naming something to give the impression that it's something else. Right? So this happens a lot in marketing, where something is given a name to give it the impression that it is something else. Right? And then also employing a temporary fix so that the sale can occur. Right? This happens with cars. Sometimes a car can be temporarily, fixed up such that it can give a few days of driving, but in actual fact, a whole lot of defects are there. So all of these will give the buyer the right to return the goods. Nowadays, they have another thing that's called what's it? It's a type of inflation in products. I can't get to the term.
Open tax.
No.
Plan obsolescence. Plan obsolescence.
You know what happens? So you have a container, right? Let's say, for example, you have a packet of chips. They keep the packet the same size, and then they lessen the amount. Or they will have a bottle with a less amount of liquids in, right? And then they sell it at the same price. Right? What do you call it? Not downsizing. There's a name for it. Right? It's a type of like inflation in goods, right? But it's deceptive. They decrease. They will increase the value of something and keep the size the same, or they'll make it smaller, or they'll make the quantity the same, and they'll keep the size, and the customer is none the wiser. And one day they realize that this thing is getting smaller, right? So they actually have a term for this, right? So that will also be haram. Right? Then we have khiyarul aib.
I think it's called shrinkflation.
Shrinkflation. Something of that sort, right? It's an actual term. If you Google it, you'll find like some studies on it and how companies do it and how long it's been around and so forth, right? Fine. So now we have khiyarul aib, the option to terminate upon coming across a defect. So we have explained this before, that when a buyer comes across a defect which was pre-existing, he's allowed to return the item. So he comes across the defect was there when he bought the item, he's allowed to return the item. Right? So here we're not speaking about a guarantee or warranty where something breaks. Here we're speaking about the thing was defective. Right? So upon that, undoubtedly the person will have the right to give it back. If a company gives a promise for a warranty and that, right, then, like I said, we won't necessarily say it's binding unless you construe it by saying that this thing shouldn't normally break in this time, therefore it's a defect in relation to the description of the product, and on that basis, you can be allowed to return it, and the return will be binding. right? So let's define what a defect is. A defect is defined as a deficiency in the corporeal, like we said, the shell, or value of the item, right? A deficiency in the corporeal or value of the item, which detracts from a valid intent behind buying the item, and such a defect is not normally found in the item, right? So what is a defect? A defect is when you have a deficiency. The deficiency can either be, for example, you have this book. The deficiency can either be a deficiency that will cause the book to cost less. So, for example, if this cover is bent, in the shop, they might sell it at a lower price, right? Because the customer wants it to be sealed. Or, for example, when something is normally sold sealed, then it's not sealed, it gets sold at a lower price, naturally. Or when something has a scratch on it or a dent, then it will be sold at a lower price. So that's a defect. Why? Because it detracts from the value of something. Because it detracts from the value of something, right? Another defect would be, another part of the definition of a defect is that it causes the utility of that item to be lessened. So that's the clearest defect, where I'm buying this thing for a particular purpose. It's defective in such a way that I can't access that purpose. Right? For example, I want to buy this because I want to write on 300 blank pages. And I come and I find that there's 2 pages written on. Right? It's a silly example, but the point is that it detracts from the utility of the item. Right? Fine. And then another condition is that that defect must not be found in that item normally. Right? If the defect is normally found in that item and it's sold with that defect, then a person will not have the right to return. The person will not have the right to return. Right? Mana gives an example. An example of this is a diesel car. The motor does not start immediately after the key is turned in the ignition. One has to wait a few moments before the engine starts properly. Even though this is a defect, it is common in old diesel cars, and therefore the buyer cannot return the vehicle. Right? So this is a case where you're selling an item, and this is especially in second-hand items. Right? So you're selling an item, the item has a defect, but that type of item is normally sold with that defect. Right? For example, a sheep. Oftentimes a sheep is sold with what we consider to be a defect, like the cutting of the tail. Right? But it's normally sold like that. So you can't take it back and say, where's the tail? Unless at the time of contract, you stipulated that you wanted the tail. Now, you have taken the commodity out of the bracket of things which normally have the defect to asking for a specific commodity. You understand that? So you make sure that you stipulate that at any time. Or read Manaka's paper on it. Time. What happens when a person finds a defect, right? But they only found that defect because they brought about the defect. Let's say, for example, you buy a car. The car is driving smoothly, but you get into a small collision. Right? A fender bender. That's the right term, right? You get into a fender bender. Allah protect us. And then, upon evaluation of the car, they find other defects that had nothing to do with that accident. What happens in that case? So Mala discusses this over here. The answer is not happy. Right? He says, our honorable student, the right to forcefully return the commodity falls away, since the item was bought with one defect, and thus cannot be returned with more than one defect. As the principle goes, harm cannot be circumvented through harm. Right? So the person cannot now bring the vehicle back and say, I want to give the vehicle back because it has a defect. Why? Because he has made the item more defective than what it originally was. Right? So you will not have the right to demand that the item be taken back in a state worse than it was worth. He says, once we know this ruling, right, then we also say that if the seller decides that he wants to take the goods back, then that will be fine. Right? If he decides that, you know what, even in this condition, I'll take it back, then that is fine. Why? Because no coercing will be taken place. Right? You have another case. You have a case where an old defect can only be known through a new defect. For example, in order for you to know that the egg is rotten, you have to crack the egg. You have to crack the egg. In order for you to know that the milk is old, you have to open the milk. In order for you to know that, so you won't buy an open milk in the fridge. In order for you to know that the chips is stale, and sometimes you get that stale chips, isn't it so? At least it's stale. So sometimes you get that stale chips, isn't it so? Now, in order for you to know that the chips is stale, you have to open the chips. But you wouldn't buy an open packet of chips in the shop. Right? So what happens in this case? Right? If an old defect can only be known through a new defect, such as cracking an egg or cutting open a watermelon, then the seller is forced to accept the return of the item. Because the nature of that item is that the shell must be broken in order for the benefit to access. So when the shell is broken, which is a defect, right, and then it's found that the item is naturally defective, the person will have the right to return it. If it goes beyond the threshold to reveal the defect, the seller is not compelled to accept its return. Right? So now the person comes and I was going to mention this, that they, I don't know, eat half of the watermelon. Right? So that happens. So this is, if the person goes beyond the threshold of, these are only a few examples. I can't think of another example. Okay, tell us.
Go to a place called buy frozen pies and like 3 trays of frozen pies and you realize one and a half of the pies, none of them are sticking. It's just so you go, you're not eating all, you're not eating it, you bake them something. Yeah, but the guys have been taken back on what I'm right.
Not really.
The one
Type.
was still good.
So I understand what you're saying, but I'm looking for an example. Think about it, we maybe can discuss it after the class. There's an example where you have a defect, right, that you're bringing about in order to access the benefit, but you go beyond the limits of that defect. You understand? You go beyond the limits of that defect. It's like sometimes you have to knock something up in order to see its schema, but in order to see it, then you knock it up too much. Right? No.
The steak is raw. Last person steak has a piece of blood in it.
Yeah. So you first eat most of the steak until you get to that part, right? And then you say, no, it's raw. That's a good example. MashaAllah, experience. Allahu Akbar. You can make an excuse, you say it was a mistake. Get it? Mistake. Fine. So there are certain conditions for returning an item. What are the conditions for returning an item? Now, you found that it's a defect. You know that the Sharia has given you the right to return it. What are the conditions? Right? For example, you buy a shirt, you find that there's a button missing. Right? Now you're allowed to return the shirt. What's the condition? Right? You have to stop using it immediately. You have to stop using it immediately. If you don't stop using it immediately, you will not have the right to return. The person can accept the return, but you will not have the right to return. Also, if you delay outside of the area of need in returning the item, then you will not have the right to return. So you leave the item laying there, right? And then you return it after a while without due cause, then you will not have the right to return. The return can be accepted, but you will not have the right to demand a return. Isn't it so? Kim salam wa rahmatullah. Questions after class. Right? Fine. So you understand those points? So an exception to this would be, for example, if we went by the Hanafi school, right, and we said that the khiyaru shart is 60 days. So yeah, you have like two things to play with. You understand that? So this covers like your store return policies, where they give you those 60 days within the contract, or they give you those 30 days within the contract. Over there, we're going to say you have the option to annul the sale, and therefore, even if khiyarul aib, option to return upon defect doesn't cover you, then khiyarul shart covers you. Right? Fine. So now we have invalid and impermissible sales. Now, okay, so this is quite a bit. I'm going to just rush through it. Fine. So you have two types of sales. You have invalid sales and you have impermissible sales. What's an invalid sale? What's an impermissible sale? Every invalid sale is impermissible, but every impermissible sale is not invalid. You understand that? Okay. Every invalid sale is impermissible, but every impermissible sale is not invalid. You got that? They say, "Bainahuma umum wa khusus." I always like to teach this lesson, that every couch is furniture, but all furniture is not couches. Every car is transport, but all transport is not cars. You get it? Okay. So every invalid sale will be impermissible. Right? They say, التلبس بالعبادة الفاسدة حرام. Right? To engage in an act that you know is invalid according to the Sharia, right? That has an element of worship in it, will be haram. So a sale is like that. Part of the sale is legislated by Allah subhanahu wa ta'ala. Allah wants it to take place in a particular way. So when you engage in a sale, contrary to the way that Allah wants it to take place, then that is both invalid and haram. Because now you're engaging something invalid, right? And you're going against the command of Allah subhanahu wa ta'ala. Right? Because Allah has instructed you to do this in a particular way. Then you get a haram sale. A haram sale can be haram either on account of something essential to the sale missing, and that would deem it invalid and haram. That's what we spoke about in the first case. Right? So there's no contracted item. Like what? Like a usurous loan. A usurous loan has no contracted item. You can see an element of hurma in there. Or one of the conditions for sale is missing. It cannot be handed over. So that sale becomes haram, and that sale also becomes, that's Mawla Zakaria's thing. And that sale also becomes invalid, right? Then you get a sale that is haram on account of something that is extraneous to the contract. It's outside of the contract. For example, you cannot trade in certain times, like Jumu'ah. So this, like Ml Muhammad Carr mentioned the other day in the class, the Asr class, the sale is valid, but it's haram. The sale is valid, but it's haram, right? Naam. So invalid sales, right, are many types. So Mala is going to run through a few here, and he says that sometimes when you listen to these examples, then you think that they are laughable examples. But when you look at the nature of these examples, then you find that oftentimes there are extensions in the modern world that are based on the same ideas behind it. For example, one of the type of sales that's haram is bay'u hablul habla, right? That to sell the progeny of something's progeny. So I have a camel. That camel has a child. I sell the child of that camel's child. So there's a camel. The camel has a child. This child will have a child, inshallah, one day. I don't sell this one. I don't sell this one. I sell the one that will exist. Right? So that would be invalid and haram. That would be invalid and haram. Right? However, there is one example where this can possibly be permissible, but that is a different contract. You call istithmar or istisna, right? Where in farming that will be permitted, where you sell the yield before it exists, right? We sell 5 years yields before it exists, but that's a separate contract, and we won't discuss it in these classes. The next one, mashallah, your question has come. Yes. So, asbul fahl, right? Asbul fahl, right? Maulana says, I found this amazing. He says, I was initially unsure whether or not I should mention this case. Why? This case, because they thought it's not a valid thing. Like, Maulana thought, this book of ours is a short book. Why should we mention such an extraneous example? Right? But this is of the cases mentioned in Hadith. I finally decided to mention it to demonstrate another form of an invalid sale and also to show the solution to such a predicament. This displays that the Sharia, though it closes one door, always opens another door for us to meet our needs. And oftentimes the door that the Sharia closes is the door of harm, and it opens the door of benefit. Asbul fahl is a type of transaction prohibited by the Messenger sallallahu alaihi wasallam. It refers to selling the sperm of a horse. This type of sale is invalid because the commodity is not quantified and cannot be directly handed over. You understand? So normally they pay for the mating to take place, but there's no quantification of that. It can't be quantified, and what you actually want is the semen. Isn't it so? This is the solution to this case is that the owner lends the horse to the buyer. That's one. Ibn Hajar says about this case, the owner may gift the semen to the seller. In fact, it would not be far-fetched to say that it is legally recommended. That is mustahab. Another case is that he can hire the horse. Right? So he wants to make money out of it. He can hire out the horse for the period and then gift the semen. Understand that? Make sense? Fine. Then you have mulamasa sales. I'm going to run through these ones. These are clear impermissible ones. Why? Because of the contracted item not being specified and the buyer being forced to accept the sale before the specification of the contracted item. Right? So the one is mulamasa sales. This refers to the buyer touching a garment that he has not seen due to it being dark, with the condition that he cannot annul the sale once he sees it. Right? So he cannot annul the sale once he sees it. So the person has to maybe close their eyes and they have to touch the garment that they want. Right? Once they have, then they have to buy it. Once they see it, they can't terminate the sale. So that will be invalid. And you can think of many other cases like that. Remember that the lucky packet? Of course. We discussed it already. And we provided the solution also. Then you get munabada sales, which means to throw. Right? This refers to the seller saying, I sell you this item for such and such a price on condition that you cannot annul the sale once I throw it to you. So the person takes your money, and once he throws the item to you, you can't annul the sale. Or he sells it to you, he throws it. Once you catch it, you have to pay for it. Right? I don't know if anybody has seen anything like this happening anyway. One of those YouTube channels, eh? Yeah, but over there, that's for free, man. Auction. No. It's definitely not auction. Who said that? Not the auction, right? Okay, so you can think of them. Then there's husat sales. This comes from the word pebble. This refers to the seller saying, I sell you whichever garments these pebbles falls on. So you'll have some garments there, then you'll sit with some pebbles, and you'll throw the pebble. And whatever falls on, you have to buy it. Right? But basically, you agree to it beforehand. Beforehand, you agree to it, and then he puts it on, then whatever you get, you have to buy. Sounds like one of those games, isn't it so? Sounds like one of those games. You go to the game shop, you put your 2 rand in, you know what you're getting, but whatever you grab is yours. When you put your money first, that's the problem. You must first select and then pay. Not pay and then you can only select afterwards, and whichever one you get, you can only take that one. Right? Those sales, those games were a long time haram. We grew up knowing those games were haram.
So like that kind of junction you say we pay before you go.
No. Ratanga Junction is different. Ratanga Junction is that there's a whole facility, right? You pay to enter the facility, then you can access the amenities. What is it amenities? Yeah, you can access the facilities. It's different. Man. It's more like a hiring contract, right? Right of usage as such. So they'll give you a general right of usage, and then maybe they'll specify that certain things are not part of that right of usage, and then you know all of that beforehand, right? So it's quite specified. Why are you trying to take Ratanga from us? They already took it physically. Now you want to annul our experiences via the Sharia? No, man. Some of the youngsters don't know about Ratanga. Eh? Muhammad, you know about Ratanga? Akram, mashallah, Akram. Okay, fine, we continue. 2 contracts in one sale. This is a problem, right? The Messenger sallallahu alaihi wasallam prohibited this type of sale, and it is deemed invalid. Right? This type of sale is explained by Simak ibn Harb, who narrates the hadith about this matter from Abdurrahman ibn Abdullah and Abdullah ibn Mas'ud as follows. It is that a person ensues a contract saying, it is such and such a price at credit and such a cash price. Imam al-Shafi'i agrees with this understanding, saying, it is that you say, I sell it to you for 1,000 paid now or 2,000 paid next year, whichever of the two you want. Weren't we saying this is permissible all the time? On camera. The camera example. Weren't we saying that it's permissible to have a cash price and credit price? What's the problem with this? The problem with this, if a person says, I sell you this book for 200 rands today, or 300 rands paid next week. 200 rands paid now, or 300 rands paid next week. If the buyer says, I accept, the sale is invalid. If they say, I accept for 300 rands, the sale is valid. If they say, I accept for 200 rands, the sale is valid. Where is the point of invalidity? The point of invalidity is when the person accepts without that acceptance being an indication of a specified price on the conclusion of the contract. And this causes a lot of confusion. No, you can take it now or later, but if you take it later, rather give me this much if you take it. Then the person says, okay, and he takes it. But you didn't specify which of the options that you want. Now the person gives it 200 rand back, you come and say, I said it was 300. But this is, no, you said it's 300 if you pay it now. Well, I give you a clear example. A person says, you know what? If you pay today, it's 300. Or if you pay now, if you pay cash, it's 300. All right? But you can pay next week 500. Then a person says, okay, and they take it and they don't pay. All right? And they don't pay. So your understanding is what? It's 500. Now they come at the end of the day with 300. Now you say no. You think it's 500 because you didn't take it. You didn't take it cash, right? So this is clear examples of how people get into confusion. So to avoid all of this confusion, the Sharia just says haram, right? Ibn Rif'a narrates from Al-Qadi that the case is understood to be the instance where ambiguity exists. If the buyer says, I accept for 1,000 rand cash or I accept for 2,000 credit, then the sale will be valid and Allah knows this, right? So we explain. The next type of sale is called Bay'ul Arbun. I'm going to take an extra 10 minutes today. Right? Bay'ul Arbun. Bay'ul Arbun refers to the idea when a person wants to buy a commodity for a certain amount of money, the amount is specified. But then he says, look, put this amount down now to secure the purchase. If you decide to go through with the sale, it's part of the price. So let's say I sell you this book for 1,000 rands, right? Put 100 rands down now. Or I sell you this book for 100 rands. Put 10 rand down now. If you take it, then it's part of the price, meaning you only have to pay me 90 rand. And if you don't take it, the 10 rand is mine. So what's the ruling on this? Right? Yarhamukallah. The majority of Shafi'i, Hanafi, and Maliki scholars have prohibited this type of sale. So most scholars say that it's haram. The Hanbali scholars, as well as some distinguishable scholars of our time, such as Dr. Wahba Zuhaili and Dr. Yunus, we have here Yusuf Rafiq al-Misri. It's supposed to be Yunus Rafiq al-Misri, have deemed it permissible. Right? So Dr. Wahba Zuhaili is a famous Usuli scholar. He's written a lot of works in Islamic finance. He's also written some works in Usul al-Fiqh and so forth. Right? I believe he's a Shafi'i scholar. And then Dr. Yunus Rafiq al-Misri is also a famous scholar in the lines of Islamic finance. So they deem this to be permissible. On account of the harm accrued to the seller. In the case of the buyer deciding to cancel, we view that arbun sales are permissible. Right? So most scholars will say it's impermissible, but they will permit it in certain instances. Why? Because there's a harm accrued to the seller when the person gets into the purchase and then they pull out of the purchase. And it gives a classical example for this. Right? For example, when you intend to hire a vehicle and pay a deposit of 1,000 rands to secure the vehicle, if it doesn't take it, it belongs to the lessor. And if it does, it becomes part of the price. Right? So that's a common one. When you hire a car, isn't it so? So that will still be impermissible. Right? But according to Yunus Rafiq al-Misri and Wahba Suhaili, they will permit it. Another example is the deposits given upon registration. You get a non-refundable registration. And over here, we can see the value of Dr. Wahba Zuhaili's view and the view of some of the Hanbali scholars, wherein they say that when you have an institution and a person registers, you turn away other potential customers. You actively turn away other business. Why? Because that person registered in good faith that they will be there. And that's going to cover you a good, sometimes, for example, if you're working in a school, that's going to cover you a good 40, 50, 60, 70, sometimes 80,000 rand for the year. You understand that? So when you lose that student in your university or your college or the like, right, then you've lost a bit of business. So when it becomes the norm that students register, but then they don't actually take the course, then they make you lose business unnecessarily. Because then people go for the second option colleges. You understand that? So in light of these type of circumstances, right, one could appropriate the view of those scholars who consider it to be permissible. Mullah ends off by saying, if no harm comes about by the cancellation of the buyer or the lessor, then arbun sales will not be permitted and will be considered to be unjust devouring of people's wealth. Right? So when is a person advised to go out of this? When there's a clear harm to the business, if a person doesn't have the structure of non-refundable deposits there, right? If there's a clear harm to the business, because that secures people. Once you have a non-refundable, it secures people to either hire, or secures them to sign up for a particular cause, and that causes you to not turn other customers away, right? But if this doesn't exist and you're using it just as a means to take people's money, then I will say that the original ruling will apply, that it will be impermissible and that money will be haram. Now, so we come to prohibited sales. The one is the example of Jumu'ah. I'm not going to get into the long story that Mona mentions here. You can read it yourself. The prohibition is not on account of the sale, it's on account of the quality of the sale. For example, the time of the sale. So it's got nothing to do with the sale itself. The sale is fine, but the Sharia says at this time, we're not going to allow you to trade. So that's what makes the sale haram. So over here, the sale will be valid. Over here, the sale will be valid in this case, but the act will be a sin. The act will be a sin. And it just refers to that period when the second adhan goes and until the end. Right? So when you get the second adhan, khutbah, that's the Jumu'ah. Right? The Arabic portion, that's the Jumu'ah. That's the period in which you cannot trade, technically speaking. The English talk and all of that, right? You can sell your akmili in that period. Right? I'm not advising it because Mala mentions here that owing to great importance attended in the Cape of Good Hope, traders have always and still closed their shops at the time of Jumu'ah. Rather, they do so before its time enters. May Allah reward them abundantly. Right? So then Mana's going to mention about COVID here because when Mana was writing this, it was COVID and they were busy closing the masajid and a lot of sad stories, right? So that's got nothing to do with the fiqh, so we won't read it. Additionally, that in order for the sale to be haram at the time of Jumu'ah, then Jumu'ah must be wajib on the people. If Jumu'ah is not wajib on the contracting parties, then the sale won't be haram. For example, like two women engaging in trade in this time, no problem, right? Or two sick people, or two travelers in a particular city, this won't be permissible. I mean, it won't be invalid. Now. So if two people come maybe to a certain country, they're both travelers and they come there just for business, and they can do that business through Jumu'ah, so would it be haram, technically speaking? Now. Okay. Mullah does go here into it's interesting. You can read it on page 70 to 71. He speaks a little bit about how Mullah came to this ruling of closing the masajid and things like that. Then another important matter: selling grapes to someone intending to make wine. Selling grapes to someone intending to make wine. So this will be haram. Why? Because it's considered to be i'ana ala al-ma'siyah, assisting somebody to do haram. Assisting somebody to do haram. Right? So the Prophet ﷺ didn't permit this type of sale. Right? To begin, our honorable student, I say that this ruling is a challenging one. Not difficult to understand, but difficult to implement. This is when we look at the impact this ruling of impermissibility has, such as closing the doors of sustenance. This is especially the case in our constrained economic circumstances. So the idea of assisting in haram is one that we are afflicted with widely in the Western world, right? What I mean by this is that we are a Muslim minority in a society where the reins of the economy are not in our hands, but mostly in that of non-Muslims. They do not know the laws of Islam, nor do they care to implement them. Most people work for non-Muslim companies, and Muslim traders trade with non-Muslims in various fields. This doesn't mean that we sit back and accept the circumstances, rather put our shoulder to the wheel and we do whatever we can. An example of this is the development of Islamic finance within conventional banks, right? In any case, when you know or highly suspect that the person will sell grapes, will buy the grapes in order to make wine, it will be haram. It will be haram for you to sell it to them, right? If he is in doubt, then it won't be permissible. I mean, it won't be impermissible. So when you like 50-50, then the sale will be valid and permissible, right? When you're less than 50% sure, the sale will be definitely permissible. You understand it? It will be definitely permissible. Now, as you know, there's nothing, and here Mullah says the important thing. If he is in doubt, then it will not be impermissible. And I counsel you to not ask about things that will harm you when the answer comes no. Says that here, right? So sometimes you want to be like, mashallah. Don't be like, mashallah. Right? Relax sometimes. Relax. Right? So whatever is a means to haram becomes haram. One of the proofs for this is the fact that the Prophet ﷺ, in relation to wine, the Prophet ﷺ cursed 10 people. The one who presses it, the one who carries it, the one who aids, the one who buys it, the one who sells it, the one who, right? So over here, this hadith gives the person the overwhelming impression that any assistance in something that is haram, right? So that's where the Shafi'is are coming from. Another,
Maybe when you saw like a pen to a sheep which is making it, for example, you know it's doing stuff yourself.
you're asking questions. So let me have this last discussion. So Mala says here, the narration tells of impermissibility of anything that is a sabab for sin. A sabab is something that causes something else, but it's not part of that thing. So when you have this, it causes the sin, but it's not part of the sin. Right? For example, selling a silk garment to a male who intends to wear it. So male can't wear silk. Selling wood to someone intending to make musical instruments. Another example is selling food to non-Muslims at the daytime during the month of Ramadan. This is based on the opinion within Islamic legal theory that non-Muslims are part of the divine address and thus duty bound by Islamic law. Right? So this is the opinion of the Shafi'i usulis. If you go to footnote number 6, in our current circumstances, a Muslim minority in the Cape of Good Hope, this matter is extremely difficult, if not impossible, according to the norm in terms of practice. I've also heard some of our scholars saying that this is of those matters wherein our practice differs from the theory. Right? This is a living law. This is a living law. Right? So you'll see, like in usul, they will mention this. But some scholars will go in the fiqh and say, we don't practice this. Right? We don't practice this because of the impracticality in relation to it. So we say in theory, what do we say that we don't practice? We don't say we don't practice the fact that we mustn't aid in sin. No. We don't practice on the idea that Islamic law is also for non-Muslims. We don't practice on that idea. We say it in theory, but we don't practice it. Right? And there's reasons for that. Okay, the last thing is Malna mentions here of a man who sells, allow me to mention a question that was raised to me in this regard whilst writing. A man sells refrigerators used to cool beverages. Is he allowed to sell those to taverns? This is the favorite question. This is a pan question. Some of our teachers responded to this question by saying that he may do so if he has no other means of income. That is, he is compelled. This fair answer led me to understand that those actions which aid in the assistance of impermissible things may be permitted in circumstances of need and duress. According to the need, we oscillate between offering this dispensation and not neglecting the standard ruling. For this reason, I did not move away from the official view of the Shafi'i school, appropriating the view of Imam Abu Hanifa, which will shortly be mentioned as the preferred practice. So what's Mala saying here? Mala is saying that you notice in the book that sometimes we say the Hanafi madhab is better on this. But over here, we didn't say it. Over here, the Hanafi madhab will allow you to do all these things. The Hanafi madhab will allow you to sell grapes to somebody who's going to make wine. The Hanafi madhab will allow you to sell silk to somebody who's going to wear it. The Hanafi madhab will allow you to sell wood to somebody who's going to make musical instruments. So Mawlana didn't say that that's the better view. This is the jihad of the Shafi'i school is what you should follow. But there are certain matters of duress wherein it will be suitable for us to give the fatwa according to the Hanafi school. Right? And Allah knows best. Right? Okay, this is a long discussion. And I think that we must make dua that Allah subhanahu wa ta'ala gives us another tomorrow morning. Otherwise, the last issue that would have been discussed would have been taking possession of the contracted item. And taking possession of the contracted item takes place, like we said, before you can sell it, you must take possession of it. Taking possession is accordance with the type of contracted item. If it's something immovable like a house, then the house must be vacated and the keys handed over. If it's something movable and it's large like a car, then it must be moved from one place to another. If it's something movable, but also it can be taken by grasp, then it must be grasped in the hand. Right? When this takes place, then exchange has taken place. By that means we would have completed the book, except for one discussion about application program interface, which takes about 4 pages. It's also an example of assisting in haram. There's one brother working in computers, and inshallah, if Allah gives us tomorrow, and then we do it. If not, then not. And alhamdulillah, bi ni'matihi tatimmu salihat. Praises for Allah subhanahu wa ta'ala who allow us to complete 70 something pages of Islamic contract law. We suffice for that. Sallallahu ala Sayyidina Muhammadin wa ala alihi wa sahbihi wa sallam. Alhamdulillah Rabbil Alameen. I think you can cut that and we'll open for the questions, inshallah.